In this video, we're going to talk about how domestic violence convictions affect gun rights under California state and under federal law. Now let's talk first about felonies. If you're convicted of any felony, then in California that imposes a lifetime ban on using, owning, or possessing a firearm. However, there's some convictions that are for what we call wobblers. That means a crime that could be charged as a felony or a misdemeanor. And in those situations, we can often restore gun rights by getting the charge reduced from a felony to a misdemeanor. And we can do this at the end of probation. We can go back years later after the case is over many times and put it on calendar and get the charge reduced from a felony to a misdemeanor. It's something that we call a Penal Code 17B motion. And usually this will do the trick. Usually this will restore gun rights. However, and this sort of turns to misdemeanor, there is a list of misdemeanors in California, a conviction for which triggers a 10-year ban on gun rights. And this includes most domestic violence convictions. So corporal injury to a spouse, domestic battery, stalking, any of these, even as a misdemeanor, will impose a 10-year ban. Now, the upshot of that is, for example, let's say you're convicted of corporal injury to a spouse, Penal Code 273.5 as a felony. Now, that is a wobbler. So if we got that reduced from a felony to a misdemeanor, then we sort of get around the felony implications. However, even the misdemeanor version is on this 10-year list, so you would still have to wait out the 10 years before your gun rights would be restored.